Okay, as we figure out the Zoom a little bit more, I'm going to do just a brief introduction of our two speakers, both judges here in Harris County, Judge Miller and Judge Collier. Judge Miller is the judge of the 190th Civil District Court. Judge Collier is the judge of the 113th Civil District Court. Both were originally elected in 2018 and are very involved in our bar associations and general community. Judge Miller won 2024 Trial Judge of the Year, Tactus. And one thing that I think is very big to note is that he was the drum major of the Golden Band from Tigerland. Yes, go Tigers. They both told me to to keep it short and casual. I was planning to read verbatim, but both of them have very impressive bios, if you will. And I'm very excited to hear what they have to say. They've both been involved in the legislation, which we'll get into more during the discussion. Drew Padley is going to be our moderator for our discussion. He's been working a lot on making sure that this is a good discussion, goes over a lot of different things. And if anyone has anything, they want to talk about during the discussion, feel free to raise your hand and he'll get to you so that we can have more of an open discussion. And if everyone on Zoom is okay and can hear, I'm going to let us go ahead and begin.
Thank you to everyone here joining us in person at Steptoe's offices and those who are joining us virtually by Zoom as well. And thank you to Steptoe. Thank you. And then finally, a very big thank you to Judge Collier and Judge Miller for joining us today and being willing to share their insight into some of the bills passed and some of the bills left for dead this legislative session. Most of you probably know that the legislature is still working. They're currently in the second special legislative session. That follows a first legislative session that ground to a halt when Democratic members broke quorum by leaving the state in an efforts to combat a mid-decade redistricting effort. The Democrats are back now and the second special session is well underway. In addition to redistricting, Governor Abbott has listed, I believe, 21 total items on the agenda, including things like legislation responding to the tragic Hill Country floods this past 4th of July, legislation to eliminate STAR testing, to regulate hemp-derived THC products, legislation related to abortion, transgender bathroom usage, infrastructure, and others. So the jury's still out on all those bills, so to speak. The special session follows a regular session that saw legislation passed related to private school vouchers, school funding, bail reform, the Texas lottery, water infrastructure, the 10 Commandments displayed at schools, property taxes, vaccines, housing, higher education, oversight, and much, much more than just that. So I say all that just to put our discussion today in context. We're not going to talk about everything that happened in the regular session, and instead we're going to focus on major legislation that's affecting the judiciary, Harris County, the legal community, and the courts. And then also focus on some of the themes that we can extract from what happened this session and in the past as well. So we have our two incredible guests here to share their insights. And so without further ado, let's jump into it. The first question that I have for each of you, Judge Miller, Judge Collier, is just, did you have any involvement in getting legislation passed this legislative session? And if so, what was your involvement?
Why don't I go first, because you had so much more to do. Okay. Mine's easy. So I'm the legislative chair of our state district courts, all 67 of them for Harris County. My goal was to stay out of Judge Collier's way for lots of reasons. So my main thing was to get the courts passed. And so hopefully we'll get 5 new civil courts online and 1 new county civil court online. And I've been working very hard to get what we'll talk about, I hope, which is the mostly for summary judgment law fixed to some degree. So that's been an ongoing thing, and that's been progressed greatly today. But those are my 2 things that I was working on. I helped a little bit behind the scenes with what Judge Collier was working on. but she's the main star of helping get things through the legislature.
That's really kind of you, Judge Miller. But first, let me thank Young Lawyers Association for having this. I think it's so important. It's a critical issue, and you're filling a void for the bar. So it was it's great that you all are at the forefront of making sure that we're having these discussions. So let me start off by thanking the organization and allowing me to be on a panel with this great judge right here. So my involvement, and actually let me stop there. I just want to make sure that everyone understands kind of the organizational structure of the Board of District Judges in Harris County, because I think Judge Miller kind of went by it really fast.
Yes.
And so when he says that he's the chair of our legislative committee, the way that it works is that all of the district judges in all of the divisions in Harris County sit on a board. And there are some statutory duties that we have to fulfill on the board. We elect a local administrative presiding judge, who is Judge Latasha Payne of the 55th District Court, and she appoints different chairs. And one of our very important committees is our legislative committee. And so on behalf of all of the Harris County District Courts, Judge Miller has been leading the way, making sure that Harris County has a voice in Austin. And so I just want to make sure that we're all on the same page, because we live in a world that we often don't really describe how the sausage is being made. And I think there's some benefit for you all to get that insight. So when you come into the courtroom and we rule on your motion, that is part of our job. It's not all of our job. There's a lot more that administratively that we have to do that are our requirements by statute. And so he fulfills that role on behalf of the entire Board of District Judges in Harris County. So I was elected president of the Texas Association of District Judges. So we have an organization for all district judges across the state. And so I made sure, hopefully, that we had a voice in the 89th legislative session with respect to our compensation. The way that judicial compensation works is that the legislature years ago decided that they were going to create a commission that was an independent body that's made up of lawyers and non-lawyers, and they look at the data and they determine a fair and just compensation for judges. This is a long way to say, although it may not make sense at this moment in our presentation, I want you all to pay close attention, because I want to have a casual discussion. I think it's gonna be an opportunity for hopefully you all to connect some dots on why things are happening and why things are not happening, and what that means to you all in the practice of law, and then also the impact to your clients. But that was my involvement, testifying on behalf of the district judges in the legislature, meeting with key stakeholders, the Supreme Court of Texas, the chiefs of the Court of Appeals, the district judges, and some key senators and representatives. So that was my involvement.
How many trips to Austin did you make?
There were so many trips, and I have 2 boys. And so it was like drop them off and then head to Austin and then come back. So this session was
A lot. For you.
It was a lot. It was a lot more than I had expected.
And she gets no more compensation for that.
That's right.
So, I mean, it was really great work. So thank you, Judge Collier.
But I feel like we're gonna have questions as to why the work that we were doing on that could have had severe consequences. And as a result of what the version of the bill that came out will also have significant consequences to your clients.
That's a great point. What Judge Collier just said, and as she's mentioned when she was speaking as well, we would love for it to be casual, and if people do have questions that they'd like to raise and make this more of a conversation, then we absolutely welcome that. So please feel free to jump in. The bill that Judge Collier was just discussing was SB 293. And the primary part of that legislation that got the most press, I think, is the judicial pay aspect of it. And so we'd love to hear more about that in due time. But I just wanted to go over some of the other provisions in it and see if our judges here today have any thoughts that they'd like to share about those. The bill is pretty broad. One provision imposes new time limits for summary judgment motions. I think that would have implications for all of us in the room here who do litigation, certainly. Have related time limits related to when argument needs to be held, when hearings need to be, or excuse me, when the opinion needs to come out, disposing of the motion, and some other time limits as well. There's the increase of judicial pay, which the base rate increased from 140,000 to 175,000. And then there's another whole issue that was controversial related to this bill that sort of held it up until the last minute, which was that the judicial pay and the legislative pensions had been linked for a long time. And so it was kind of a push me, pull you situation that made it difficult to get the bill across the finish line. So part of this bill decoupled those two features from one another.
You'll have to remind me to give the backstory on that.
I would love to hear all the backstories that you have.
Zero. Yeah.
There's also another set of provisions that reform the process related to judicial misconduct complaints. There is a provision I'm very curious to hear your thoughts on about judges tracking their time and having it be reported to state officials, which was very interesting to me when I saw that. Sort of puts you back into the billable hour zone in a sense. And then pretty minor, but again, another limitation on judges that they can only participate in teleconference hearings from the courthouse or some other court facility. So again, Judge Collier might have thoughts on sort of general themes about these limits being imposed on judges, but perhaps Judge Miller, since I think you rose your hand for this before, do you want to talk about the summary judgment provisions?
Sure. I think we would agree this is in the lens of accountability and transparency for judges. I don't think it has anything to do with practitioners in the courts. I think it has to do with keeping us on a timetable and making sure that we rule. So I had this passed out. This is the SB 293 provision on summary judgments. And I've been asking my docket so they know what this is. And most people, 99% of people, have no idea what's happening September 1st. So essentially what this says is you file a motion for summary judgment, it must be heard, and it must have a ruling. There is no way for you to withdraw the motion for summary judgment after September 1st from being ruled on, whether you like it or not. So the judge must set up a hearing within 45 days of the response being filed. It doesn't start when the motion is filed, it's when the response is filed. And then the court must, after that 45th day of consideration, then have a ruling within 90 days. And again, you have zero control. I think what it also does for us, it gives us the power to set your own motions for a hearing. Because the other part of the other section is that our clerks keep track of how many times we don't hear a motion, a summary judgment motion within the time frame. And if we don't hear it within the time frame, we get a ding, we get a report, like we didn't do that. And if we don't rule within time frame, we also get reported for that. And that information goes to the Office of Court Administration, that then it gets reported to the chief, that gets reported to the governor, lieutenant governor, and a bunch of other people, what's happening. Again, this has nothing to do with you. It has everything to do with us judges. But it doesn't change 166A from the standpoint of you can ask for a hearing 21 days, and a response is filed. So a lot of that you still can control. But just realize when a response is filed, we start the clock and we have to consider the motion by submission or by oral hearing, and then we must rule on it. So there may be a lot of unintended consequences like denials. I certainly heard a couple summary judgments today and gave 2 to 3 month continuances based on discovery not happening enough. Arguably under this new bill, I would have to just deny those motions and deny without prejudice, not to resetting, but to refiling. So you couldn't just reset the motion for summary judgment. You'd actually have to refile it. And that is something that's you all need to be aware of before you start filing motions for summary judgment that you want to just have reactions to, that what are the unintended consequences of doing that now? Well, it's come September 1st. I have been working with Representative HYLA.
Before you move on to the potential amendments.
Yep.
A practice tip. So, you know, when you file your motion for summary judgment, you do it for various reasons. One may be strategic. You are about to go to mediation, or you think that you can strategically work a better deal for your client if there is a pending motion for summary judgment. Knowing that, there's still some discovery that needs to be done. So making sure that you are okay with having your motion not being successful. And then ultimately, if you lose, like fast forward to trial verdict, are those attorney's fees recoverable? After it's not, you have not, you know, you were not successful on that motion for summary judgment. So would that be recoverable? Point being, until it's amended, and Judge Miller is going to talk about all the work he's doing to potentially work out some of the unintended consequences, you want to be really careful before you file a motion for summary judgment, because if you are going to get a denial, what are those implications? Your client now thinks that they're not really fully understanding the scope of what's happened. And so you're now showing that you have not been successful on a motion, when in fact the case is the right type of case for a motion for summary judgment, but just not at this moment in the litigation, which would be fine pre-September 1. But now, since the law has changed, the way you practice will need to adjust until hopefully the good work comes into play.
Which is still not perfect work, by the way. It is a legislature. And I think I could say that openly that, you know, not all things are perfect coming from the ledge. We try to make it as good as possible. Also, there's no differential between or difference between no evidence motions for summary judgment and traditional motions. And whether how the DCO would dictate that is also a question. I'm under the impression, I think that others too, that our DCOs would still control. And so if you filed no evidence motion before our deadline, then probably denied
Right away.
right away.
Because that's what the statute says too. But it's not just discovery, right? It's also, everyone in this room is a human being. So if someone's giving birth, someone's on maternity leave and they want to argue it, some family emergency happens, ordinarily what would happen, you all would agree. You would say, absolutely, I'll move the summary judgment, I'll pull it down. I will extend that professional courtesy that the disciplinary rules require me to engage civilly with other lawyers. Now you can't. So you have to understand that likely you would need to let the judge know, hey, I'm not opposed. I understand that you may have to deny without prejudice. I understand that my opposing counsel is on maternity leave, or there's a death in the family. And we raised all this with the legislature before they passed it. I said, often I'll have lawyers that will tell me, hey, I'm putting my mom in a nursing home, or there's been a diagnosis in my family, or I'm getting cancer treatment. And lawyers are very gracious when it comes to real valid reasons why they can't respond to a summary judgment. But this statute as of today does not take into account for that.
No, not at all. And you were much more part of this than I was, but I think SB 293 was such a large vehicle for so many things that I know that you try to help adjust this during session. It was just too unwieldy to make these kind of changes at that time. So the new, I may have a question on the one that's going to affect on September 1st.
I have a question. I don't know if it's really addressed by the statute, but for summary judgment applies in this type of circumstance, your judges feel like it's still helpful to put those forward, or do you think maybe not as useful or given the time frame you guys are going to be right away on?
I think it's still helpful. I don't think anything changes from what you want to look at as far as getting this stuff in front of the judge. I will tell you that in trying to I would say fix the bill. I've had lots of conversations with Justice Christopher, who's the chair of the Supreme Court Advisory Committee. So her job is to deal with these things and they're looking at changing 166A, primarily around this kind of stuff. And one of the ideas is to add reply times to 166A that would drag things out a bit. Now, that may be good, may be bad. A lot of our summary judgments aren't these big Goliaths that require hundreds of pages of exhibits and things. We get a lot of small ones that, and a lot of them that aren't contested to. So we'll see what they do. I don't think your practice should change as far as that goes. Do you?
I think that you should, as always, even before this, but I think maybe overemphasize the writing and being concise and not making a point in 5 pages that you can make in 1 page, because we do have to quickly get this out. And so for us to be able to digest the information, I think maybe stylistically, there may be some changes. Substantively, no, because we need the information, especially in a reply if it's necessary. But if it's not 100% necessary, I wouldn't, just because it's gonna just take longer for us.
I think the best thing is to know the judge,
Mhm.
right? Are they going to do that or not do that? There are also other unintended consequences. You may have some judges that want to put these things more on submission dockets than offer oral hearings, just for tracking purposes. You all may not know this, but we don't get notice of every filing in a file. So we love you all, but like, I don't want to know every time motion for summary judgment is filed because you may not have said it. But now we're gonna have to figure that out, and we have to work with our clerk's office to figure out the notice. We certainly don't know when responses are filed, because they can be filed at any time. So there's some potential unintended consequences that come from actually how we administer these things. So let me talk about the fix. Yeah, sorry.
Another question.
Yeah, sure.
Thinking about appeals and
Mhm.
what's gonna happen, say, if you grant a summary judgment on day 91. Do I have an argument on appeal that says we granted this outside of the time?
I don't
Like,
think so.
what happens?
I don't think so. I think it's just a mechanism for our chief and folks up there to know how we are doing as judges. That's my
So
impression.
there's no recommendation for argument.
I don't think so. I think that the judge can rule on it when they want to rule on it still. They just will get a mark that goes to the big people in Austin. Yeah, these things, right?
Since, a written ruling, that's just your standard order, or are they expecting the trial court judges to go business court, like full?
Oh, absolutely not. It's just a written ruling that's marked in the records to say that judges ruled on something.
So just thinking out loud, because if, let's say you have a big MSJ that has a lot of complicated issues. With this time frame, like you said, would it almost, I mean, this sounds ridiculous, but would it be better to file individual MSJs on each individual cause of action to like streamline? You're just focusing on this MSJ for this, and then 2 months or 2 weeks later, we file the MSJ on this issue. That way you're only looking at specific issues in a short amount of time.
I think it's gonna be dependent upon per judge. If I was in your shoes, that's how I would do it. Just because you never know. I mean, there's almost 3,000 cases on any given docket, like in between 2,000 and 3,000 cases. And like Judge Miller said, we don't know when things are filed. We only have it before us when things are set. And so during that time period, you may not know how many other complicated motions for summary judgment there may be, or other issues that the court is taking up in that time period. You may be the only one, and there may be just very small motions for summary judgment and it works out, but it may be the opposite. And so I mean, and Judge Miller may have a different perspective on it. I feel like you're probably more efficient and faster. And so maybe for his court, file the whole thing and he'll get it for you. But for me, I would think I would want it piecemeal, just because you never know what may be happening during that week. And so it just gives the judge an opportunity. Now, am I talking about the ordinary run-in-the-mill motion for summary judgment? Absolutely not. I'm talking about like what you posed. Yeah.
Well,
Like, I have a case with 10 causes, about 10 claims and.
Yeah.
It's all intricate of breaking them down individually to give you.
Grouping it where it makes sense
Yeah.
and separating it when it is like relying on separate evidence would be a practice tip.
unintended consequence. I let my clerk set as much as she wants to set on a Monday. So we had 8 MSJs set for this Monday. Now, we ended up with 3, right? But if you're filing 10 MSJs when it should be 1, there are other courts that max out MSJs for their court. And so you may be taking up spots on your multiple motions for summary judgment that should be 1 and delaying that for others as well. It's like calling the court up the morning you settle and say, hey, we settled our jury trial. And we're like, okay, well, we
Yeah.
can't have jury trial today because we need to get someone else on board. So I mean, I do encourage if it's large pieces to do it individually. But I also will be
Yeah.
crazy and take as many as,
Yeah.
we can take.
But setting it at different times, that's what you're saying, so that the deadline is, you get a full, right?
And different issues that, yes. So the change, comes from, conversations with Justice Christopher, people on her advisory committee, Representative HYLA, who's in this area, who I worked with extensively on the new courts. So he and I have a really great relationship. He's a really great guy, although he's a Republican and I'm a Democrat. We can get along and do things together. And so he also looked at the bill and said, this is what's wrong with this. And so what we fixed primarily, well, the first thing we fixed was the deadline by which time is tracked. So it's on filing. So we know when a motion for summary judgment was filed, and then the time starts clicking. It lets us have 60 days to have a hearing. But you can continue that hearing another 30 days upon good cause. The court's docket, if the movement is okay with it. And there's another one.
It takes care of all those issues that we just mentioned, right?
And so it also lets the movement withdraw the motion from consideration. So that was a big piece that we wanted, that I wanted, was to let the movement really control the destiny of their motion. So we wouldn't have a problem having to rule on everything was filed. Now, we still don't want you to file everything and not, really consider it for ruling, but that was a big piece of it. And then it gives the judge 90 days from the date of consideration, submission, or oral hearing to rule on it. So we still have the spirit of the law, which is making sure motions are heard and ruled on, but with a little bit more flexibility to get things through. Again, no difference between no one's motions for summary judgment and traditional motions for summary judgment. There are a lot of things that we really wanted to put in here, but time is short. It's a second special session. So hopefully the next legislative session, we can work on fixing some things as well. But as Justice Christopher and I agreed, and the rep agreed, and he worked really hard on this, by the way. Like Mono was a trooper for us on this. It's as good as we can get right now. And it passed 130 votes to 1 vote in the House today. And so we expect it will fly through the Senate tomorrow. We hope the governor signs it. If he signs it, it's effective immediately. And maybe we're not in the old SB 293 motion for summary judgment world. Maybe we're just starting with this world, which would be great for us for tracking.
Yeah, I was just wondering when it was gonna go into effect. You answered the question.
So if it's not by 2/3 in the Senate, or the governor, if it is 2/3 and the governor doesn't sign it, then it's 90 days from the session ending.
And what happens if they don't approve it July? Like you might have some little
Mhm.
cases that are governed by the old rule,
Mhm.
unless they say it's retroactive.
Our clerk's office will kill us because
That will be really hard.
Because we'll have tracking on all these different time periods and we're talking about how we're gonna keep up with it, but I think Judge Collier and I are rule followers. So we want to make sure that we have notice and time that
Mhm.
should be set for hearing and that we're rule on it. So if we're in 2 different dimensions of this thing, then it's gonna be really crazy for us until that we pass through that, but so that's where we are with the MSJ. Well, I've got to get a lot, a lot of shout outs to Justice Christopher and Mono for helping get it where it is, but it's.
Another practice tip would be a very kind letter reminding the judge of the deadline. I think that would be really helpful. And not relying that all the wheels are working from the court's perspective, especially if we end up in a weird situation where we have one set of rules for like a couple of months and then a new set of rules. So if you fall within that or your firm falls within that, I would shoot out an email to your firm and say, hey, let's make sure we are helping our judges. And we send a letter saying, hey, judge, the deadline for this, we need this ruling by X date pursuant to what passed, right? Like 293 requires you to rule by this date. And I think that would be a very kind thing for you all to do until the clerk's office and the courts can get our act together with all of the technology that we need to support this.
We try to introduce that idea, like, reminder of findings of fact, there's a law to prompt us to do that. But again, this is more about us than it is about you all. So that didn't make it through. Maybe that's a change in the future. If you do that, again, we don't know when you file letters. Right? And
Call the clerk. Can you get this letter to the judge?
call the lead clerk. So we have, I don't know how many people file our stuff, but I have my lead clerk, we have an assistant clerk, and then we have a bunch of people in the clerk system that file things for us, and they don't know the protocols either.
They don't.
And so if you're working with my court, send Tammy an email, or call her so that she knows that you filed a letter in the file and that she can bring it to me. With every case that you do, by the way. So
Whoever's filing for you at your firm, I would make sure that they are aware who the lead clerk is of that court. Because if you happen to be filing something and our lead clerk is gone, we have someone that's floating in, I may not get the information that you're calling about. So it is helpful to get the name of the person. Obviously, be kind to our staff. They deal with a lot of people. But I think that's important that people don't recognize, especially for judges that may be in between clerks. Understanding that there may not be a permanent clerk, or if our clerk is out of town or on leave, it is like the wild, wild west. But it's helpful because then there's more transparency for you all in understanding what may be happening. The judge may not realize things are happening. So let me figure out a different way to get the information to her or him, like setting a status conference on a law day docket and getting before the judge and saying, hey, judge, I wanted to raise these issues. And that way you know for a fact the judge has heard it.
can I judge one thing? Of course I can. Sorry. So September 3rd, our Commissioners Court is going to take up a request by our district clerk's office to add 12 more assistant clerks to our division. We have 24 courts. We now have 12 assistant clerks. I think that's the hardest job in the courthouse because that assistant clerk has to report back to a lead clerk and a lead clerk and a judge, and we all do things differently. And that's a hard role to play. And then he or she may get transferred to another court for a day to work for a different judge while she's filling in for someone, or he's filling in for someone who's on leave or just sick that day. And so we really want to try to get 24 assistant clerks for the 24 courts. That may not sound important to you, but it's really important to us. And so if you had the opportunity to have a commissioner's ear or something before that, it'd be really great. The actual financial note is not that big on that. We don't pay our assistant clerks very much, but it would be hugely impactful, I think, for our courts.
Yeah, you get your orders faster.
Yeah, so will this apply to like just new cases that are filed or all MSJs regardless of when?
MSJs,
Okay.
Oh. Yep.
MSJs.
Mhm.
Was there an amended bill number that we're watching?
House Bill 16. It's the omnibus court bill. I don't remember the Senate companion to that. I think what Mono told me was their plan was to take the House bill and vote on that in the Senate. It would be the cleanest way to do that. And everything in the House bill currently, I think, has been agreed to by members of the Senate. That's what I understand. So sometimes the sausage just works better that way. So I'd follow House Bill 16. This is one of those priorities that has to get through. When the governor vetoed the original court omnibus bill because of an unrelated expunction issue, and put it back in the special session, everyone I think that I know of said this has to get through the session. It has more than just our little our little MSJ fix. It has courts for a lot of different counties, fixing things in really small counties, how it operates. It has a jurisdictional increase for county courts going from, I think, 250 to 325. So the max jurisdiction in a county court would be $325,000. It doesn't change our base for state courts. Our base stays the same, which is $500. But it allows people to file bigger things in county courts and unclog our dockets. Happy to have you on an $11,000 case, but you can move that faster, more efficiently, probably cheaper in a county court. They are also doing another county civil court, and that's in the bill. I'll just talk about the courts and then I'll
Yeah,
get off
please.
the microphone here. The bill has 5 new state civil courts. 3 of them would start January 1st, 2026, and then 2 would start October 1st of 2026. The governor would appoint the first judge of those courts. And then the way that I read it, the nominee for the election in November, there wouldn't be a primary runoff, would be people that were voted on by the precinct chairs of both parties. So it's a little different. You don't get to choose who you want necessarily by popular vote for the primaries. That's changed in the 2 courts in October 26 because the filing period will be open. And so people will file directly for those 2 courts. Make sense?
Before I switch gears, any questions on the new courts in Harris County? All right, yeah, so that judicial omnibus is the one that that was vetoed at the end of the regular session, and so hopefully that does get passed and signed into law before too long, before the session's out. All right, so the last big ticket item that we had to discuss would be that judicial pay
Yeah.
provision, and you sounded like you had a lot of juicy details to offer.
We're closing out at 7?
I would stay here all night. I don't know.
No, I can't. But I just want to make sure.
Judge
That's
Carter,
what it's scheduled.
What's the schedule?
you-
Okay.
you can write a book
So-
on this.
So, so I think like the overarching theme, because I'll touch on pay, but I think it's important for every legislative session from this point forward, lawyers need to really engage, because what we're seeing is a trend of an intentional, systematic encroachment by one branch to another co-equal branch of government. And so what does that look like? What do we do, or what do we in this room have to do to ensure the foundation and the fabric of our democracy? Because really, lawyers are really the only ones that fully grasp the implication of the legislative branch encroaching upon the Supreme Court in rulemaking. Because motions for summary judgment is a rulemaking procedure that they now are legislating. When you look at 293, and regardless of your position on bail, the legislature is saying, if you don't follow the law on bail, we will eventually remove you from the bench. And there are some real implications to that, because whoever is in the legislative branch, they can take that issue and move it from bail to whatever you want. TCPA, motions for summary judgment, whatever area of law, maritime law, healthcare. If they find, if whoever is in Austin decides that I don't like the way that judges are ruling, I will change the way that we handle Judicial Conduct Commission. I will fundamentally give more power to lay people to decide judicial conduct violations, because that's what they did. They removed the state bar positions, because the Texas State Bar had positions on the Judicial Conduct Commission, which makes sense because when you have a conduct violation on a judge, it's helpful for lawyers to be a part of that process, not just lawyers, but also former judges, because they can look at and understand what has happened and they have more insight. What they've decided is that that's not how we're going to do it in Texas anymore. And we are going to allow the governor, another branch, to take control over the Judicial Conduct Commission. So now you have two very political folks from Harris County that are not lawyers on that commission. It's really important because we're going to see probably a new day on what happens to Harris County district judges and Harris County county judges. Because we'll see whether or not the bail works for them. Because you're going to see judges potentially having to deal with the Judicial Conduct Commission. None of the definitions in bail, right, can be defined because federal courts have told us you can't violate the Constitution. You can't give the judges have the discretion because they're not robots. We're not doing this by AI. This is judicial discretion. And so when you have bail being set at a discretionary level, but then you have a conduct commission that says, well, we think it was you consistently did not follow the law. Well, what does the law say? But now we can remove you from the bench. And I raise that to a bunch of civil judges because bail's probably not where it's going to land. That's not the end of what we may see in the future. So keep an eye on where it may land. Judicial compensation was really 13 years overdue. So for you all connecting the dots, politically, the landscape of what the judiciary looked like, what did it look like 13 years ago? And Austin stopped giving a cost of inflation adjustment. So all state employees and county employees get a cost of inflation adjustment, a COLA, except for judges. Judges have to go ask for additional funds for inflation. So when anyone tells you that judges got a pay raise, I mean, that's a great little soundbite for the media, but it actually brings us to 1991 district judge salary level for what they did. It was merely an adjustment for inflation. And
Not enough.
And right. And so when you had mentioned the delinking and the delinking, I think that's important. So anytime that the district judge salary changed, it impacted the retirement of the legislature. Our pay is also connected to our prosecutors in the state. It connects so many because a lot of the statutes and by constitution, everything is based off of a district judge pay. Court of Appeals, Texas Supreme Court, it's all based on the district courts. That's why that 293 was such a big deal because it impacted so many salaries far greater than the district judges. And so what happened is that last session when they voted to change the salary of a district judge, they didn't increase it, but when it was being discussed and it got voted unanimously out of the House. It failed in the Senate last session. Republican representatives that voted for it because it passed unanimously in the House got primaried and got little postcards mailed to all of the primary voters in the Republican Party. And they said, look at this representative. They voted for their own raise for their retirement. And that wasn't true. They were actually voting to increase district judge pay because it had fallen over a decade. And so that was the huge problem, is that you had some Republicans that were having a real political consequence for doing the right thing. And so that was what the fight was over. And, over the last 72 hours, of this past session, the 89th legislative session, I felt like I was doing CPR. I was so tired, but it was all on this issue because you had folks that were potentially going to risk their position for voting the right way. And that's why you saw the House really fighting to de-link it, to make sure we don't have these issues in the future. The reason why compensation is so important is because there were, I know that a lot of you probably have cases beyond Harris County and probably in other parts of Texas. And there were some real problems in areas where recruitment and retainment of good, qualified, experienced district judges was just like tanking. And so before the session started, I had very senior like district judges contact me from all around Texas saying, if it doesn't happen, I'm retiring. No pressure, Judge Collier. But I just want to tell you the facts. Like, we're not going to last another term. And so that's really impactful for your clients in your cases, because if you can't recruit and retain qualified people, I mean, that's a problem. Galveston County, their oldest bench, there was a vacancy, the last vacancy that happened. There were multiple people that ran for that bench. This last vacancy, which was probably within the last 2 to 3 years, one person ran from both parties. So they literally filed an application and they assumed the role of district judge. I mean, that's the problem when there's a huge disparity between the compensation and what is being made. And look, okay, I'm not trying to compare it to the private sector because you all get paid a lot more. The service, there's a service aspect. And so you have to understand that you're going to take a pay cut. But if you heard the Chief Justice of the Supreme Court say that one of the Supreme Court justices took a 200 or 300,000 pay cut from a government in-house, like at Governor Abbott's lawyer. I mean, it's from one governmental position to another. Like, that is like, where's the pay parity? We have some district judges here on the criminal side, on the criminal district bench, that shared with me that they took a cut of 150,000 a year. There's a real financial sacrifice that district judges are making, not including all the other things that have to be done that are to us, you know, like to the either family detriment or family. And this is not like, oh, feel bad for us. I think that this is something that's important for us to discuss, because when we fight in the legislature to stabilize the judiciary, we're going to need some help from you all when we not just ask for compensation. There has been a representative, the name escapes me, close to here in Houston, but every session he files a COLA bill for us.
Yes, yes.
It starts with the S.
Yeah.
It'll come to me. Schofield. And he files a COLA bill because he's like, I think this is an encroachment upon the judicial branch. They shouldn't be coming over here and asking for this. We should just be doing an adjustment for inflation, like the federal judges. Like, we should put things in place where this doesn't have to happen. They don't have to show their timesheets to get a pay raise. Because when we have to show timesheets and we're the only elected official, we're the only branch that does that, is this kind of where we are now in society, where we're taking away as much judicial discretion as possible? It may not impact your docket or your cases at the moment, but it, I think, is a trend that we need to focus on for next session and the sessions coming.
I'll add my 2 cents here, which is, I think the question for lawyers is, what kind of bench do you want? And I think judges are the worst to advocate for a pay raise. I think the advocacy should come from the lawyers and say, we need our judges to be better compensated so we can draw better talent or keep talent. Because that may not be happening. And certainly I was one of those categories where when I took the bench, I was fortunate, it didn't matter really what was being paid or not paid. And we had some colleagues that joined recently that had no idea the salary was so low. And now we have people running, it's a different retirement system altogether.
Yeah, they retire, they slash not this session, so the 88th legislative session, they slash the retirement by 2/3 for any new judge. So it's like worse than a 401. And then all the timesheet requirements, all of the accountability, there's a real attack on the judiciary. There's a ton of security threats, and none of that's being funded. So that just leads to a judiciary that's not fully funded, because it's not just about compensation, it's also technology, assistant clerks, it's about filing processes, making sure that we're using AI when appropriate with our bookkeeping, so we actually know what motion you all are coming in on, and we can actually pull up the documents. I mean, it's things that are super basic to very complex issues. But I think we need, as a bar, especially Harris County, because we're so powerful here, to figure out constitutionally, what are we going to do to preserve the judicial branch? Even if you set aside compensation, but what are we going to do when they are trying to close the doors on substantive causes of action? Even if you're on the other side of the bar, right? Because that's going to affect you, because that's your practice area. Even if you're a defense attorney, now you have no clients. You have no cases. Not that we want cases for our own salary, but because that is what America is about. We resolve our disputes in court. You harm someone, you go to court. We resolve it in a civil manner. We have a constitutional right to have a jury. So like, what are we going to do to ensure that although there may be extremist views pushing legislation in Austin, and folks are in real fear and threat of losing their position, what are we going to do to support them? What are we going to do to tell them that enough is enough? Like, yes, I may be a defense attorney and I think that some cases are not legitimate, but you shouldn't close the door to all, because I may be that person that needs to sue the next day, right? So that's where I'm going to leave it, because I've gone 2 minutes over, and I hate to be disrespectful of time.
I will say also, you're more in the weeds, but there are a lot of part of the statutory scheme that the ledge included language that it was not to be reviewed by the Supreme Court of Texas. That the law this is what it is, and there's no review by the courts. So
Someone has to sue on all these things. So when you talk about separation of powers and constitutional issues, we're going to see lawyers, as we've seen in history, protect our country from, falling apart.
So I think it's really important for all of us to understand what's happening, what's being pressed, what's being defended, and play a vital role, whatever that role is, on one side or the other or all together. I mean, if it's just happening in Austin without people knowing about it, then it probably is not the best way for things to happen. And see what has failed this session and what may come up next session. So, House Bill 30 failed this session, and it may come back up next session. And House Bill 30 was limiting economic damages to $1 million in catastrophic cases. That was, the miniature was $1 million, and didn't matter what kind of case it was. That's what I read.
I don't know. Is that a society we want to live in?
So
I don't know.
But those are things you need to pay attention to. I'm not going to tell you which way you should go on it. That's not my job. It's, I'm precluded from doing that.
But can we ask the question, is it appropriate to ask the question, would $1 million on some of your clients' cases, would that impact or substantially change business practices? $1 million? Would that actually impact? Because really, a verdict is supposed to say you can no longer do this. You need to make sure that car seats are safe. No baby should die. would $1 million, I mean, on the budget, because you guys see the business aspect of like, how much can we settle for? How much is it worth? And then when is it a real sting where the business says, no, I'm going to make sure that products in Texas are safe for Texans? And I'm not really advocating, I'm just saying you all have great insight
Yes.
into
yes.
whether $1 million makes sense in some cases, not all cases. I'm just saying in some of the really big cases.
And just remembering that sometimes these statutes don't get revisited. So the cap on med cases is still there. And that passed when I was in law school, I think. I've got more gray hair now. So it's been a while since those things have been revisited. And maybe, things happen and bad things happen, and maybe the compensation should be more for what that person has to go through now. But that's, we're putting a lot of pressure on you younger lawyers. But the question for you all is, what do you want the future to be? When we were doing new courts through the Commissioner's Court, which they have to fund it, I had the presidents of the law schools come and talk. And I think you all participated. I think that, knowing what the future is and how you want to practice in Harris County, what you want to look like, and the access to courts for new courts, right? The access to better judges, if you can get those better judges in Harris County. Those are things that you need to be looking at. I'm gray. I'm going to retire at some point and make a lot more money than being a judge, because I'm not making much money being a judge. I want one more term, but after that, I think I want to go back and make some money. But your future is all ahead of you, right? I'm going to sound like you're a high school, graduation speaker, but as a lawyer, you're just saying out. I don't remember when I was your age, right? I just don't. It was so long ago. But you need to take it up and you need to make it happen. You need to figure out what it is that you want to be and advocate for that, no matter what it is. This is your time to do that. You're young, you've got the energy, you've got the vision. Just don't let people make decisions for you for their own political gain or their own economic gain. That's something that you've got to pay attention to. You're lucky in some respects, depending on where you are, that you have people that are my age. They're really paying attention and spending a lot of money to get things done that they want to get done. Their interest may not be aligned with your interest. And I think that's a very important thing for you to watch.
I told a lot of people in Austin when I would meet with them, I would say, I think it's probably rare that you get lobbyists, people to lobby on issues that's against their own self-interest. In the sense that I'm trying to spark competition. I'm an incumbent, right? Like there are judges that are doing this because for the greater good. It's for the future of the judiciary. So regardless of whether it spurs more, because some people are like, well, that means that more people will run for judge. Well, I think that's a good thing.
So if I can, I
Yeah.
would close this kind of story, but so in the last 72 hours for SB 293 was a real big mess. Both chambers had agreed on it. It had gone across conference committee, came out, voted on it. And then when the House sent it over to the Senate for their final confirmation, they had a point of order and it crammed to a halt because now they want to have the decoupling for one more time. They want to couple it for one more vote, that vote this year. And the Senate are much more protected in some ways than the House are. And so the Republicans in the House, like Judge Collier was saying, knew they were targets of being primaried if they voted for their own pay raise for this even one time. And it was a real big gut check for them. And I'm very happy it came out the way it happened, but it was really stressful for them. And I think a lot of people did things that were against their best interests for the better interest of Texas. And you all don't know who those people maybe are or aren't, but just know there are people out there like that, they will take a personal sacrifice that may not get elected again because of what they think Texas is. But you have to have a voice in that. That's the last I'll say that.
So just in closing, I think things that you could do to assist kind of what we've been talking about is when you are with your family and friends or in community, to actively engage the disinformation about the court system. I think it's incumbent upon you. Like think about the oath that you took and make sure that when there is disinformation in the community, that you explain it and you clarify and you really take the time to talk to your family and friends about it.
Thing on that, I'm sorry.
Yeah.
It's actually your duty and responsibility as lawyers that we can't speak for ourselves, and it's in the professional conduct code that you lawyers are required to do so for us. Because if we don't have advocates out there like you all who know what's happening, if there's public discourse that is incorrect, that is not factual, it is your job to correct it for us because we can't do it ourselves.
You know, when people overemphasize or hyper index like an issue like bail, you know, do you want your child to get bail if something happens? Do we still want the constitutional right? Like if we have to make that decision, like as a community, do we want that? And what does that look like? Because the conversations that are happening outside of lawyers is snowballing. And there are people that really are like, just as soon as there's an allegation, the government should be able to lock you up. Okay, well, I mean, if you take it to the voters, change the law, and the judges will just follow whatever happens in Austin. But like, that's where you all come in. And so I charge each one of you to make sure that you have these conversations. And if there's an opportunity where you're in community and you need participation from judges, you probably have the best county in all the I've seen all the other judges, and I like to brag on Harris County District judges. We are accessible to you all. So if there are real issues that you want us to come talk about or answer, please reach out to us. We are more than willing to come out and explain some of these things because we're civil lawyers, but there are a lot of criminal lawyers, district judges that go into the community all year long explaining what the news and what Elon Musk has put $2 million in this last campaign cycle.
There are two constitutional things on the ballot in November, right?
Yes,
One is bail
yes,
and the other is judicial commission.
yes.
So changing the makeup of that.
So look up who the two people are who are nominated by Governor Abbott and talk to your family and friends and figure out for yourself whether you think it's wise that makeup of the Judicial Commission rule on violations that are filed by pro se's, by people that are in prison, or just a disgruntled person, right? Like someone that believes that a judge has done some official misconduct. Look it up and then let your family and friends know that they really need to go out and vote.
All right, well,
You're
that,
welcome.
you have.
Sorry for the lecture.
No, I was gonna say, you know, I'm very inspired and y'all have 1.5 years to start training and get ready for the next legislative session. And fight for these judges and others and the legal profession. But it's been a wonderful presentation and thank you so much for joining us and sharing
Thank you.
everything you had to share and for all your hard work during this session. So.
I just have one announcement, please take leftovers, there's lots of leftovers, and a big thank you to Drew.
Yes.
You guys are the guy. And, yeah, you over-prepared Drew.
You should have seen his outline.
Yeah.
Oh my goodness.
I was like, wow.
He's good.
I was like, we can't talk about most of it.
Oh, I'm supposed to share with everybody the CLE number. Do you want that? Yeah.
Speakers are.
There you go, Lucy.
Jared, those were the two judges since I've been here that I've met in front of, and both of them I just.
Cool.
We got more documents and share file.
Course number is 174288568. 174288568.
You know, that's.